fine. Very glad to hear you after a long time.
Morning.
Morning.
Good morning, Warrior sir.
Morning, ma'am. Morning, everyone.
Good morning to all.
Good morning. Good morning.
Madam, good morning.
Morning.
Good morning. Good morning. Good morning.
Good morning. Good morning. Good morning.
ഫോണിൽ പറ്റത്തില്ല. ഫോണിൽ പിൻ ചെയ്താൽ മതി. ഇനിയിപ്പോ അഭിയത്തിന്റെ പിൻ ചെയ്താൽ
വേണമെന്നില്ല.
ബട്ടൺ
Time is 10:30. It is already 10:30.
The session is The session is about to commence. We request all the participants to mute your mic and audio and video. Good morning to all the dignitaries present in the session, participants, and my dear friends. With immense joy and exultation, I feel privileged to extend my warm welcome on behalf of Bharat Mata School of Legal Studies, Kerala, India, to all present here for our international webinar, Lex Conscientia 2020. First of all, I would like to introduce myself, Abhijit M., and Alphonse Rose Thomas, your moderators for the day. To proceed with this session, I further call upon my friend Alphonse.
Thank you, Abhijit. At his best, man is the noblest of all creations. Separated from law and justice, he is the worst. These are not my words, but they are the words of a great noble man, Aristotle. Yes, it is indeed our responsibility to know the law around us, both as a lawman and as a layman. Therefore, Bharat School of Legal Studies, Kerala, India, brings to you our international webinar, Lex Conscientia 2020, which focuses on unveiling the lawyering skills of students by enlightening them about the modern trends that are being observed in the civil courts.
Bharat Mata School of Legal Studies is a center of excellence in legal education affiliated to NG University and approved by Bar Councils of India, New Delhi. Besides, believe that all students have the drive for excellence. Is on interactive learning through case studies, group discussions, seminar, debates, moot courts, and other related activities. These tools serve as an effective instrument to sharpen decision making, leadership, team building, and analytical skills of students. Bharat Mata School of Legal Studies is established by Bharat Mata College Educational Trust, is managed by the Archdiocese of Ernakulam and Gumali. With immense joy and pleasure, we welcome you all to today's session on behalf of Bharat Mata School of Legal Studies. Now, I'm profusely elated to welcome our director, Very Reverend Father Sebastian Vatican Paran, for the welcome speech.
Dear respected Honorable Dr. V. Sebastian, the Principal of Bharat College of Legal Studies, Dr. Celine Abraham, our Vice Principal, and Honorable Resource Person, Sri Advocate Sri Lal Warrior, International Accredited Mediator, dear faculty members, and all the participants and dear students, especially 7th BA LLB students of 2016 batch of Bharat School of Legal Studies. We are at the digital world, and the influence of digital world is very much in every field. First of all, I want to tell you, this digital world has influenced even the court in a positive way. So the class on modern trends in civil court definitely will help each and every one of us to enlighten us these modern trends and the way, the procedure of the courts, especially of civil courts. So it's really indeed. And first of all, I want to thank our principal, vice principal, and also the faculty members who arranged this meeting, our Aliyah sir and Dr. Anna, and 7th BA LLB students of Bharat School of Legal Studies for their strenuous effort in order to make this day wonderful. And very meticulously, they have planned it. And really appreciate our students because everything they have done with perfection. And really wonderful. And also I thank the faculty members, Dr. Anna and our Aliyah for their inspiration to the students. And as we are in the modern digital world, we know there are many trends. Even right at the beginning of summoning, WhatsApp double tick is considered as a piece of evidence, summoning, piece of evidence or summoning. And also we know electronic media stored or transmitted in digital form definitely can be considered as a piece of evidence at the trial. That's also a new trend that has been developed. Even digital signature, admissible piece of evidence, video conferencing, and admissibility of interview in TV as evidence. So these are some of the modern trends. And recently, and in this pandemic period, we know that even virtual court is also established by Supreme Court, and they have given the direction. So we are really, we have to know what are the modern trends, and we are very much happy that we are having a good resource person, very good resource person, Sri Advocate Sri Lal Warrior. He is internationally accredited mediator, Area Chamber UK, accredited mediator and conciliation project committee member of Supreme Court of India, and he has got a long-standing relations with Bardama School of Legal Studies. He is always there for our judicial magistrate training program and various other classes as a guest lecturer. And we are very happy, our Advocate Sri Vairya and all the members, and in a special way. And what is the effect of this modern trend? People, all these modern trends leads to people friendly, first of all, because they can easily approach and make things easy. That is another important thing, because we need not worry about many things and going physically going there and on. So make things easy, make things quick and fast. That is another advantages in this modern trend, and make justice more effective in all the sense, and it is given to the people. Make things less expensive. That is another thing. Things become less expensive with this modern trend, and make things accurate. And these are some of the advantages, almost 6 advantages. People friendly, make things easy, make things quick and fast, and make justice efficiently given, and make things less expensive, make things accurate. So I really thank the modern trend in a positive way. It's really helping the humanity, and especially in carrying out the justice system. And one thing I want to mention, even all in this modern trend, we shall not forget the human touch. As I had worked in prison and the world, this video conferencing, and people from the prison used to tell us we are not able to speak very fluently to the judges and all. But let us have that limitation. But we not forget that human touch in all modern trends, human touch should be there. We should take into consideration. And with these words, and stressing the influence and also the modern trends, use of modern trends, I want to inaugurate this great webinar. And I really appreciate almost 251 at the webinar, and also we have got live video in the YouTube channel that is also watched by many, and really it is successful and really wonderful, and we will have a good time, and we will know much about the modern trends in civil courts through our helping hand, Sri Advocate Sri Vairya. And I thank everybody once again. I am thanking everybody. With your blessings, we inaugurate this webinar at this moment. Thank you.
Thank you, Father, for the guiding words of yours. To take our session further, I once again welcome all our participants as well as the chief patrons of our Bisalts community, Reverend Father Sebastian Varkubaram, Director Bisalts, Very Reverend Father Biju Tekenet, Assistant Director Bisalts, our Principal Dr. V.S. Sebastian, our Vice Principal Dr. Selin Abraham, and our Senior Faculty and Placement Officer Emmy Aliyar, and after all, our Chief Guest, Advocate Sri Vairya, to our today's session. Today, for this session, I'm very much obliged with the presence of our Chief Guest, Advocate Sri Vairya, a man of distinction and a fountainhead of illuminating ideas, and indeed an inspiration to all of us. Advocate Sri Vairya is a known face in the field of mediation. He's an internationally accredited mediator by Area Chambers UK, and is also accredited by the Mediation and Conciliation Project Committee of Supreme Court of India. In addition to this, he's also a member of the Kerala High Court Legal Service Community and Adalats under the Legal Service Authority, India. He has been practicing in the High Court of Kerala for more than 20 years. Further, he is a member of the International Junior Chamber and has been involved in the protection of the rights of mentally ill and differently abled children. He is also credited to have recorded more than 300 settlements in court-referred other disputes. With utmost respect and gratitude, I would like to invite Advocate Srira Warrior to enlighten us on the modern trends in civil courts.
Hello.
Yes, sir, it's clear. Proceed with the session.
Very good morning to everyone. And to me, it's certainly a privilege and pleasure to accept any invitation that the Bharat Mata School of Law. Anytime, I've always been at their beck and call. And this, I'm sure, I'll be much more happy to address for the simple reason that this is managed by the students. And from the day one that they have been contacting me, I was noticing the kind of enthusiasm and the enterprise that they had, each one following up things and everyone getting involved in this. I sincerely congratulate all those organizing students and also the guiding faculty. And as I know, the college has always accepted any good idea that we give. And almost from the beginning, I have been associated with it as a guest faculty. And therefore, this is just as an obligation or as a matter of duty that I address you all in your program. I have been in the practice for more than 31 years. Introduction appears to be from a very old profile that has been published in the net quite a number of years back. And though you gave me a lot of importance to the mediation aspect, let me tell you that I have been in the civil trial for all these years. And I've enjoyed civil trials than anything else. And being in the civil trial, I was also lucky to get introduced to the criminal side and being a prosecutor, a special public prosecutor, a general prosecutor, and a government trader for almost 10 years. And I believe it is because of my civil practice that has helped me to shift even into the criminal side without much of a difficulty. And also to other specialized subjects, like the customs, like the other taxation laws and all that, without forgetting that I am a civil lawyer and I continue to be in it. Today, the topic is of relevance, and the topic that I've chosen is modern trends in the civil court trial. There has been very conservative convictions that the lawyers hold. At the same time, there has been a lot of contemporary developments, and that is what is to be enlightened to the younger lawyers, because I don't want them to be going into the old conservative style, which has led our courts to have a lot of pendency. Today, there are several techniques which helps a lawyer to assist the system of justice or the courts to help them discharge their judicial work or the adjudication obligations. Code of Civil Procedure is nothing but, it has to be understood in a very simple way, is a codified rules or the codified set of procedures when it comes to civil adjudication by a judge. Therefore, I always used to name this as the guide for a judge rather than to a lawyer. It becomes relevant to a lawyer because you are assisting the judge, and therefore whatever he requires has to be understood by a lawyer. And therefore, the relevance of learning CPC also comes in. We always say this is the Gita, Quran, or the Bible for an adjudicating officer or a judicial officer. Whenever he has a doubt, he goes back to the Civil Procedure Code and as an authority, he asks the doubt and the court always gives an answer. It is so voluminous that it covers every aspect of civil adjudication. And the size is not to be worrying you, because there's a way in which you approach the CPC, and the moment you approach in the right way, it is like capturing a person with a nice smile, and you become the best of the friend, and CPC becomes the best of your friend. So Code of Civil Procedure is the rules relating to adjudication in civil procedures, civil cases, which are codified and given to you. So when there is a code, that becomes a code of conduct for the judges. I may not go through the whole thing today. I have chosen those topics which would help you understand the code in a general manner, which would also give you some kind of an interest to go through it holistically. 80% of the code may not be relevant to a particular case, but choosing what the 20% which really affects your case is more important. Therefore, it would be my attempt to let you know how to choose or how to find the 20% which are very relevant to you. I've chosen, go to the first slide. I've placed a few pictures or slides which might make it easier for you to understand the code generally. This is what I thought. In the first two slides, I have pointed out what I would be touching today, and that would be the preliminary aspect, and the most important would be that you have to read the object. And the object is, it is to consolidate the rules of procedure when it comes to civil adjudication. Therefore, it becomes or adjudication in a civil court. It becomes very important to understand two concepts in that. Are these the rules which are applicable to all civil adjudication? The answer would be no. Wherever there is a special court which may also handle a civil dispute, and if that court is given certain special procedures to follow, then to the extent it doesn't, it conflicts with the code, the other special rules would prevail. You may find it from section 4 as to exceptions to the application of the provisions of the code. Therefore, this is, though it is a very comprehensive code, there is also a possibility of exceptions when it comes to special courts, and which you will always find in the rules relating to the constitution of that court or the tribunal, and also the rules of procedure, the special rules of procedure, which are mentioned over there. 2. What is a civil court? It clearly says that a civil court, or I can, as a guidance, I will tell you, each state has a law which prescribes what would be the civil courts in that particular state. For example, in Kerala, it would be the Civil Courts Act, which says what are the different courts we have here. So that names a municipal court, a sub-court, and a district court as in the trial side. And if you have certain other jurisdictions like in other states, they may have a civil judge, junior division, a civil judge, senior division, a district judge. So the nomenclature would be a little different. So as to what constitutes a civil court in each state becomes important for you to look at. The next one is, the court says it's a civil court which has to handle. The initial area would also give you a picture as to how the courts are constituted, or what is the status of each of the court. So, for example, most of the students being from Kerala, and I know I'm aware that there are students from other states also. It is generally the lowest court of civil adjudication, which, for example, is a municipal court, and certain areas it is a civil judge junior division. It could be the next level judge, who could be a subordinate judge in Kerala, and it could be a civil judge senior division in other jurisdictions. And then comes the district judge, which remains common in all the areas. And the other two courts would be subordinate to that of a district judge. This is how the constitution is. Now, the second part comes to the institutions of what I would be giving is the institution of previous one. In part 1 itself, I have given the headings as suits in general, which would take to section 9 to 35B, etc. More important are, when it comes to trial, it is the institution of suits, which you will have to understand. 2, summons and discovery. And 3, judgment and decree. Look at the major 3 areas or stages which are originally contemplated under the code. It is, you present a plaint and you say you have instituted or commenced a suit or proceeding. The first suit is understood as a proceeding which is involved in adjudicating a civil dispute. All need not be suits. There could be original petitions also, but the rules are more or less the same, except where it has been mentioned in the code itself. When it is a suit, you may number it as an original suit. But if it is other proceeding which is understood to be like an original petition, like a succession, OP, etc., they are given a special nomenclature like original petition succession, original petition divorce, original petition, etc., etc. So it could be a suit as well as an original petition by nomenclature and practice. Next one is, once the suit or the proceeding commences. Previous one. First one. Then the second stage would be the principles of natural justice. You give an opportunity to the other person, and the judge would certainly issue a summons. We will be certainly going in detail. I'm just trying to touch the subjects. Therefore, the word summons, for 2 purposes. One is to comply with principles of natural justice, whereby you give him a chance to say whatever he wants. 2, the judge wants to know a lot of things from him. So he can summon him, ask him to come before him, and the judge can get acquainted as of right from the person. Judge would like to discover all those information, all those materials which are relevant for him to study the case and to make sure that he doesn't commit any injustice. He doesn't commit any error. He has not studied. It shouldn't be that, he could not study everything. He could not study all facets of the factual aspects, and he makes a mistake. So he discovers everything. He allows all the parties to discover what they want. Once he understands everything, then it is his duty to analyze the whole thing, deliver a judgment. And judgment, certainly we would be explaining what a judgment is. It is a judge's job, but as a lawyer, you should know it gives you a very convincing explanation as to why he has arrived at that kind of an opinion, or why he gives that kind of a judgment. And the decree is the summary of the judgment as to the operational part, as to what I should be doing as a party henceforth, what the other party should be doing towards me or should not be doing, would be summarized. So it's the obligations and duties which would be, and the rights which would be narrated in the summarized manner in the decretal portion. It also speaks about negative sanctions. Assume you do not cooperate with the court. What happens? If you do not cooperate with the court, then court will certainly be able to give you certain kind of negative sanctions, like interest, costs, and so also at times certain other actions like detention in civil prison. Now let us get into the rest of the topic. The next one is the part 2. Next. Part 2 may not be, part 2 takes in execution, which is not part of the trial. Each of these parts itself possibly requires hours and hours to be explained in full. But today, with the limited time that is given to me, let me take you to the most important stages in the trial. The part 3 becomes very important. In the course of, or once a suit of proceeding is initiated and the judge gives a judgment at the end of the trial, there are certain incidental proceedings which becomes very important. The words are incidental, and which are incidental to a delivering justice or in the adjudication process. It's so easy to understand in a different way. Wherever a judge personally cannot do certain things, not everything, this is confined to certain things, the judge can take the help of a person called a commissioner who would help the judge do those things which otherwise the judge himself would have to do. Therefore, incidental proceedings are incidental which are so attached to the proceedings which a judge can avail himself for the purpose of a better performance or convenience. Part 5 would be very important. They are called special proceedings. Part 5, they are special proceedings. Like this also helps in taking care of the adjudicatory process, simplifying it wherever the court can avoid. So find section 89, which is nothing but the court directing people to go into ADR, so that it's alternative dispute resolution mechanisms or modalities, whereby the court can concentrate on those things which are very contentious and where the judge's role is necessary. And secondly, where matter could be resolved in a suitable or appropriate other mechanisms, where the judge may not be wasting its time for that particular purpose. You will find 91, 92, 93, etc., which relates to special proceedings related to where the public interest is involved, like when there is nuisance to public, a special kind of suit. So also when there are trusts, public charities, etc., you have section 92, which takes care of those kind of special situations. Next, very important is the supplemental proceedings. Supplemental are again similar to incidental, but incidental is where the judge delegates his work to someone, whereas supplemental is more of a preventive or a protective measure, wherein ultimately once a decree is given, in the meantime, if somebody can defeat the whole process or the whole objective, what the court would do is it would give those interim orders which would be necessary to sustain the subject matter of the suit, to protect or prevent from this being destroyed or the object being defeated. So supplemental, incidental are not in all cases. They have its own purposes, its own objects. The court may invoke incidental. Parties may seek for supplemental proceedings or interim orders under part 6. Then I would certainly be going to the relevance of the second area in the code, which is called the orders. It would be very easy to understand the two parts distinctively. Remember, section starts with S, or the section substantially gives the scheme of the code in a summarized manner. And you will find in most of the sections it would say, as may be prescribed. The section would end with as may be prescribed. We would understand in different words that when we say as may be prescribed, it means as may be described or detailed elsewhere. This description or detailing is normally given in the orders. Therefore, wherever there is a section, there would certainly be, in the normal course, not for everything, of course, for major sections, there's an expansion of its own provisions through orders. So you will find, when you say section 26, you will find order 4. Similarly, there would certainly be an extra order detailing as to how the whole process is to be proceeded. Then there you have the appendices, which are excellent examples when you have a doubt. They are formats, and they are meant for judges. They are meant for lawyers. They are meant for, there are appendices which are meant for both. I would certainly be taking you through all that, and I would also make it much more easier. Now, it is always said, when the sections give you the scheme of the code, the orders gives you the orderly pattern, very systematically organized, orderly pattern in the code as to trials. So I'll also take you through the orders in a very orderly manner, which would make you easily understand and which would also easily register in your mind. Next. I have highlighted a few things. I just want to finish off a few processes, steps or stages in the whole proceeding. And then we will see how each stage would be handled by a modern lawyer or a judge. I mentioned it earlier. The objective of the code is very important. An act to consolidate and amend the laws relating to the procedure of the courts of civil judicature. So I said, what is civil judicature? And court of civil judicature is the civil court, and procedure is the process which it would follow, the rules that it would follow under this, which could also be different when it comes to special courts, or wherever there are special rules reserved, it would go that way. Next. Let's see this. The court comes into, the judge becomes functus only when a proceeding is initiated or a suit is commenced. Prior to that, the judge has no role. You may do whatever you want. The court would come in only when a suit is commenced. Now, a suit is commenced or instituted by presentation of a plaint. Now, I have mentioned certain provisions on the right. The first is always the section. Section 26 speaks about how to commence a suit or how to institute a suit, and it says by presentation of a plaint, a suit is commenced. Very interestingly, we always write, we do not ever mention order 4 when you present a plaint. Most of the plaints that you see in the courts would certainly carry this plaint presented under order 7 rule 1 of the Code of Civil Procedure. But it may not be right in doing so, in writing it that way. You would always say a plaint presented under order 4 rule 1, and the wordings are similar to that of section 26. So where section 26 speaks about presentation of a plaint, order 4 also uses the same words, but it gives a little more explanation as to how it should be presented. It should be in duplicate, and what all things should be looked into. So order 4 says in 2, every suit shall be instituted by the presentation of a plaint in such other manner as may be prescribed. Those prescriptions come under order 4. Order 4 very clearly says that plaint shall, when you present it, it shall comply with all the provisions relevant to a plaint which are given under order 6 and order 7. Therefore, every student of law who intends to get into a trial, especially civil trial, is bound to look at order 4 in detail, and more so to make it, non-defective or it's perfected. Make sure that you go through order 6 and order 7. We'll go in detail. I'm just trying to summarize, take you through that. So 4, 6, and 7 speaks about institution of a suit by presentation of a proper plaint. Is that fine? On the top you find section 26 is elaborated by order 4, and in compliance with order 6 and 7, order 6 will also, I'll just, for your information, order 6 speaks about pleadings generally. So pleadings would include any substantive pleadings that you have, which is the plaint or a petition, and the written statement that you file before the court. So it covers the plaints as well as written statement. When it comes to plaint, the relevant rules are, the order and rules are those contained under Order 6 and Order 7. It also uses another sentence. In every plaint, facts shall be proved by affidavit. Therefore, earlier this was not the practice, but after an amendment, you can't just casually say anything. Prima facie, you file an affidavit saying that whatever I have stated in the plaint are absolutely right. And how do you prove? These are normally stated by way of an affidavit on oath. And there is always an affidavit attached verifying and confirming on solemn affirmation that whatever I have stated are correct. That is, whatever I have stated in the plaint are correct. Next. The next step that you would see in a court is having instituted a suit and commenced the proceeding. The judge is expected to make sure that principles of natural justice are complied. Order 5. It summons the opposite party, asks him to appear and answer the allegations or defend the claim by written statement. Now, therefore, Order 5 itself specifically refers to the word written statement or answering the claim. And therefore, a written statement or the defense statement that you file is contemplated in Order 8, which also forms part of the pleadings. So the next stage would take in Order 5 and consequently Order 8. Judge issues summons, party answers, appears, answers to the court whatever is necessary, and answers it by way of a written statement. This is generally to be done within 30 days time. So you have a 30 days time which has been mandated for the purpose of written statement. And if you are decent, gentle, and if you want to cooperate with the court, you would file the written statement within 30 days. Now, we'll get into the next one. Interestingly, you have section 30(31) under the code. Section 30 speaks about discovery and the like. Discovery and the like. And I'm sorry, summons, you will find it in 27. I did not mention the section. 26 is initiation, commencement of the suit. 27, once it is commenced by way of a plea, you issue summons under 27 as contemplated under section 27 under the code. Now the next stage is section 30 and section 31. There are several other sections in between, but please make sure that these sections are fully understood well. 30 and 31 stages, the court would like to know all those material things which it would require for the purpose of arriving at an excellent inference. Think of a judge as a research scholar who is asked to give an opinion on certain factual scenario on the basis of the laws that are available. So he is a legal research scholar who understands all that you have, the problems that you face, the difficulties that each side have with each other. He studies the whole issue and he understands the law, the relevant law, and he gives an excellent opinion as to why first party should refrain from certain things or why he is entitled to certain things from the second party, and the second party should comply with such kind of a direction. And once he says this with all justifiable reason in a very understandable language, then the judge becomes a perfect judge. He does not even, the parties do not even need anybody else to help them out. They can just understand the reasoning. They would be convinced, and an appeal itself would be meaningless because they have understood very clearly as to what is right and what is wrong. Now, for which purpose? He has to discover all the information. Now, there are several provisions which would be relevant under this. Section 30 speaks about discoveries. Fine. 31, issuing notices from third parties. So, discovering information, gathering information from third parties is 31. Issuing summons. 30 talks to, speaks about information being gathered from the other parties. Now, the relevant orders are order 10, 11, 12, and 16 are the ways by which a judge would gather all the information that is required, and it is the prerogative and the privilege of the judge to see that all the information comes before him. Not for the parties to play hide and seek, that he would in present of the thing, he would only, he would hide so many things which may not be good to him. That is probably in the not in the right spirit, and that is the reason why in the subsequent amendments of 2018, when it comes to commercial courts, you will find there is yet a drastic change of even directing every party to produce all the information which be bad to them or which could be good for them. They are supposed to disclose everything, and you are also supposed to give a disclosure statement saying that I have placed everything before the court. All those information which is within my possession, control, or custody, and I have not concealed anything. Now, it has gone to that kind of a stage. While in the conservative trial practice, you are taught what not to be presented, what alone to be presented. That has been the trend, and today things are getting a little different. But as on date, those rules are made strict with respect to commercial courts, unless the court under these provisions asks the party to place all those information which are relevant, which according to the judge are relevant, which according to the opposite party is relevant, before the court. Now let us take order 10. This is on the first day. The judge is expected to ask the parties as to how much is being admitted and how much is being denied by the other party or either of the parties with respect to the opposite side pleadings. The first posting, therefore, normally has to be beyond 30 days. Why you say this is because you are entitled as a party to get 30 days for filing the written statement. The rest is a discretion of the court. So after the 30 days time, the court is sure that the written statement is available and both the parties have placed their versions. Now each party gets a chance to look at the other party's versions and confirm whether he is right in taking a contention or not, as to how much he would be withdrawing, how much he would accept when it comes to the other claim. So the first day of hearing, that's when parties appear on the first day, the court would certainly look at this, rule 1, as to whether allegations or what allegations are being admitted by the parties. The allegations raised by the opposite party is being admitted by himself. Then, how much is being denied? It gives a fair idea to the court, and court understands it in a very, very clear picture as to, okay, this is this kind of a sort where I have certain things to be looked at. I certainly have to do certain finding or research and give an answer. People have not accepted each other's case. Therefore, the next stage is summarily elucidates certain relevant facts. But this is very informal. I have mentioned it as informally ascertaining as to whether they admit or not. So also elucidate, he is inquisitive as to what relevant materials are available. And they would even ask the parties as to summarize their cases on the first day. I'm sorry to say this procedure is seldom ever practiced by the judicial officers. And therefore, a major step is being lost. Next would be certainly Order 11. Order 11 again explains as to how to discover, how a party can gather information from the other side. Sorry, just take the... Yeah. So 10, 11, 12 and 16 are methods by which you elucidate formally. This is very informally by the court. In the other one, the party is compelled to, whereas in Order 10, he is just asked and it is an informal proceeding. Then it comes to formally confirming, and you have 11, 12 and 16. Next. Let us read 30. 30 comprehends all these. That is order 10, order 11, order 12, order 16. After this, probably I would directly get into the orders, which would be more elaborate. So I'll just go through the sections for you. Subject to such conditions, limitations as may be prescribed, the court may at any time, either of its own motion or on the application of any other party, make such orders as may be necessary or reasonable in all matters relating to the delivery and answering of interrogatories. There are questions which one party can ask. The admissions of documents and facts and the discovery, inspection, production, impounding and return of documents, etc. Therefore, the first one takes in specific orders or interim directions to other parties for disclosure of information which it has and which probably the other party or the judge himself needs, disclosure of the documents that he has, disclosure or admission of certain facts. These are done on the basis of orders of the court. Now let us take B, issue summonses to persons whose attendance is required. So there could be third parties who are not before the court, and one party says, look, certain things are available with the third party, so let us gather that also. Therefore, under section 30, the court can also invoke order 16 and issue summonses for gathering information and getting it before the court. It can also say any of these things that the court wants people to express, it can be by affidavit. Now, when you go to orders, you will find that the order very specifically states that most of this information has to be on the basis or it has to be supplied by way of an affidavit. Next one. Now, you have so many things before the court. Court has got most of the documents. Court has got admitted areas. Court has got disputed areas, etc. Now, court has so much. It has got so many documents, and some parties say the document is not even acceptable. Sir, that is a forged one. And all the kind of contentions are also available, because it would be possible for party to even object to certain documents when they file an affidavit of objection. They need not even produce, they can even say all these kind of things. Now, some may say that, no, I will not be able to produce these documents because they are confidential in nature. The Secrecy Act comes in. So there is a question whether the document is covered under the Secrecy Act. All these would be questioned. Therefore, and he has read both the plain as well as the written statement. All these are available before the court. Now the court is thinking as to what am I supposed to be deciding in this. So what are the issues, the questions that it may pose to itself for the purpose of ultimately getting all answers are called issues. Order 14 relates to issues. So it is very important for a lawyer even to bring out or culp out, the right issues which are to be placed before the court. 15, sorry, next. Then I go, court has got the issues. Court would now try to find out answers for all its questions. And ultimately, the summary would be, or the conclusion after all the answers would be the judgment that you would be able to give. Let us take order 18. Order 18, now under section 30, I said gathering information, discovering, proving, all that has been used in section 30. And what does order 18 say? 18 is basically, it is to get to know the truth directly from the parties and their supporting evidence. Somebody has kept this. Somebody has not muted the mobile. Could you just, there's some disturbance coming in. Yeah, it's basically getting to know directly from the party's mouth. That is what order 18 is. Order 18, rule 2 becomes very important, and I would stress a lot on that. That is exactly what we call as the day of the trial. Though trial means from start to end until the judgment, what we normally call as the examination, the action in the court happens in order 18. So you certainly will have to go into it. But I am a lawyer who feels that order 18 by itself can be avoided. Order 18 requires the involvement of a judge. And most of the time, the parties are in the queue because the judge has not had the sufficient time to take your case, because there have been so many other cases pending. So if there is a shortcut or a bypass to avoid this stage, then that is what any successful trial lawyer would look at, without compromising all that information that has to go before the judge. Next. Once all that has been gathered, I just take Order 18 Rule 2 for your understanding, because without understanding this, you will not be able to understand why we are invoking 10, 11, 12, all those provisions, Order 11, Order 10, Order 12, all those techniques. It is basically to supplement this. Once we invoke all those techniques that we have under 11 and 12, then Order 18 Rule 2 becomes irrelevant or insignificant. On the day fixed for the hearing of the suit, or on any other day to which the hearing is adjourned, the party having the right to begin shall state his case. Look at this. The party has the right to state his case, or the judge says, you state your case to me. So he states his case and produces evidence in support of the issues which he is bound to prove. Now, this is very simple. This is something the party can always tell the judge on the final day. Let's take the second part of it. The other party shall then state his case and produce his evidence, if any, and may then address the court generally on the whole case. The defendant he is not even bound to adduce evidence. Whereas in the first one, the party shall state his case and produce his evidence. So there has to be a version, there has to be something to substantiate that, and not merely a version of a party. Then the second one, defendant can defend even without any evidence at all. So 1 and 2 has a little difference. The second party, the one who defends a particular proposition or a claim that has been raised by the other party, can easily even defend without any substantiating material, merely on certain statements that he places forward. We'll come back and discuss this in a little more detail. Can I have the 3? Let's just take 3 also. The party beginning may then reply generally on the whole case. Very interesting. We have always seen the first party stating his case, adducing evidence, and thereafter he leaves. It is your court. You must have seen the lawyer saying, sir, it is your court. The floor is yours. And he gives it on to the defendant's counsel, and the defendant side, adduces evidence. Thereafter, the plaintiff's counsel comes and says, yes, it is mine. Now I argue my case, and then the defendant comes in. But look at 3. 3 gives a different connotation. The second party states his case, he adduces his evidence, he also generally addresses on the whole case, because he is the better party to say. He is in an advantageous position to say, I have heard the plaintiff's case and evidence. Yes. Now I have stated mine. Therefore, I feel holistically I can now summarize and give it. Now, if he is a fair person, he will even place the plaintiff's case. He will say, this was my case. The evidence is such which is probably acceptable to me or may not be admissible in court, or court may not even receive for something. So he would summarize. Then, if the first party feels that such a summarization is not sufficient, then he may even answer the same. Answer to the summarization that is given. But probably, unfortunately, the conservative practice is not this way. It has been going on a different level, and that is how it has been continued even today. Though the code 3 has been there for a long time. Now look at this. In 2002, a rule has been added, 3A, and of course 3A, 3B, 3C, 3D. 3A introduces something very interestingly. Any party may address oral arguments in a case, and shall, before he concludes the oral arguments, if any, submit if the court so permits, a written note which is a written statement. You normally call it as an argument note. So you may even submit an argument note in support of whatever you have said, to make sure that all that you have stated has gone into record. But you have to do this before you conclude the argument. And unlike what is being practiced, I am also submitting what has been practiced now is, yes, I will also be submitting argument note, which should not be the style. It should have been concluded, it should have been submitted before the conclusion of your argument itself. Now, there's one more thing that you look at in Order 18. Rule 4 says, as per the new practice, it is this way. Chief examination has to be by affidavits. Cross-examination, now that is something new. It has to be done physically. It is cross-examination is basically to counter all that has been stated in the affidavit, the chief examination, the chief affidavit. Therefore, a cross is normally has to be on a physical platform, and it can be done by the court, or it can be at the court can even appoint a advocate commissioner to act on behalf of the judge in taking down the the cross-examination and the answers that he gives. Very interestingly, we'll look at one thing. What would this come into? Here is one instance of incidental proceedings where judge substitutes himself by someone else and makes him do what the judge should have been. That is an incidental proceeding. I'm just giving an example. So commissions is basically appointing commission to do such a work is supposed to be an incidental proceeding, which is aptly applied in Order 18, Rule 4. Next. Take a break. Are we having a break? Just have one more. Now I take you to the last stage in a trial. And after that, probably we'll have a short break for everyone. The court, after the case has been heard, and what is 18? 18 says hearing of parties or hearing of the case. So after 18 comes 20. The court, after the case has been heard, shall pronounce the judgment, and on such judgment, a decree shall follow. This is something which I had already mentioned. That comes in section 33. And the corresponding order, which speaks about how you have to write a judgment, within what time you are supposed to write a judgment, what all should be the contents of a judgment, etc., are detailed in Order 20. So this is generally the introduction as to what are the stages of trials. After this, we would certainly be going into the organized way of handling a trial. Is it fine? I believe you can have a short break, and the organizers would certainly. What is the administrator?
Thank you, sir. May I without
Yes.
interruption? Thank you, sir. May I without interruption? I would like to inform that we will be going for a short break, and the session will commence at 11:45. We request all the participants not to exit the link. Kindly remain in session. All the queries about the session will be answered soon after the session. Please place all your valuable queries in the chat box, and all the participants are requested not to write your email IDs about your information in the chat box, as a link would be sent later after the webinar in the chat box, and you may fill those to get your certificates. See you soon after at 11:45. Thank you.
Thank you all for participating in our session. The further session will be continued after 11:45. This is to inform you all that a feedback link will be provided soon after the session to claim your e-certificates. And we again remind you to switch off your audio and video as well to get a better experience of our session. Thank you.
Excuse me. Hello.
Yes, sir.
Yeah. Just check if they're carrying a CPC barrack.
Okay, sir.
It
I
also-
request all the parties.
Most of them should be at home. So if they're having
Yes,
a
sir.
CPC barrack, just ask them to keep it in front of them. It becomes much easier for them. Okay?
Okay, sir.
Just if they have it, otherwise it's fine. Good.
Okay. So as our chief guest is informed, it will be a much better experience if you could all have a CPC barrack so that you can have a better experience of our session. Thank you.
லைவ் வேணும்டா இருக்கு ஐயோ பாட்டு
Once again, good morning everybody. I request our guest, Sri Srilal Varya sir, to continue with the session.
Welcome back. Hello.
Yes, sir, we can hear you.
So you may proceed, sir.
Yeah, 1 second. Yeah, am I audible? Is it okay, right?
Yes, sir, you can proceed.
Yeah, fine. Okay. Yeah. Now, there has always been, as students probably you would have seen, that you have never checked, you have not gone much into the orders. And it has always been my very seasoned expression that orders give you a very orderly pattern of the trial. Fine. Now, first what I thought is, I'll just take you to the orderly pattern of the orders, which even otherwise you will certainly go into. As in when you start drafting a plate, complying order 7, you would be bound to look into so many other orders which becomes automatically relevant, without which you cannot proceed further with the drafting of a plate. Now, for an easy understanding, if you can just have your index in front of you, I'll just tell you how the whole orders are organized. It's always two parties are born. And being human, the moment there are two persons, they certainly have this kind of thinking ability which God has given. And it is a little more today. And therefore, they have different perceptions about the very same thing. And people don't agree with the other person. One. And they start disputing or having conflict with each other. And they have no bad intention at all. They have no bad intention at all. They all have good intentions. They're expressing it. They're openly expressing it. But unfortunately, they are disagreeing on certain things. Now, this becomes a complicated issue when my disagreement with something becomes something which affects the other party, or his disagreement with what I say is actually affecting me in my life. And then I get annoyed, or he gets annoyed. And I get aggrieved. There's a grievance that he is not accepting my version and it is affecting my life. In such a situation, it becomes an aggrieved party. And if it relates to civil matters, then you have to find out a solution. Therefore, we say an aggrieved party goes to the court. So for which you need to have a party first. Therefore, parties are born first. And in course of time, because of their ability to think, they have different versions or different stories about the very same thing. They have a frame of mind with respect to a particular thing. So they think only in that way. And they develop a story out of it. And the other one probably disagrees it. And the aggrieved party has to go and present it to a very neutral person who has got the authority to listen, who has got the authority to clarify. So there is always a third party who is an authority and who is a neutral person. He has the knack of judging as to what is right and wrong. We call him a judge. And the system is the court. And it is his process which is actually governed by the CPC. Fine. Therefore, let us look at the order now. What comes first? The parties come first. Now, if you check at order 1, order 1 speaks about parties to suit. It's easy to remember. So anything you relate to parties, you will automatically go look into the provisions under order 1. And you will get every answer. Now, this becomes a little more clear when we go through order 7 while drafting the plate in a perfect manner. Then, second part is my story, the frame of my story and the frame of his story, which has actually contributed to a dispute. Second comes the frame of suit. Frame is what? The stories which relate to the proceedings, or the stories that are to be heard by the judge in the suit or proceedings. Is that fine? So whenever you have an issue as to what is to be stated, how a story has to be stated, etc., You will immediately think of the second stage. Look, I was born, I have an issue. So second is I have an issue. Third, but unfortunately I can't say. I am not able to present my case, or I am not here. It has to be presented before somebody. Therefore, who will present it? Anybody who is recognized to be a person, recognized by this particular law as a person who can represent any of the parties and present the case before him. He is an recognized representative. So if you look at Order 3, it speaks about recognized agents and pleaders. So whoever is a representative is an agent of mine. That is 3. Not so easy. I was born, I have an issue, I need to present it. I can't present it, I am in Dubai, my brother is here, he is recognized brother, partner, a father. All these people, or a managing director, all these people are recognized by the court to be fit to be an agent to represent. But it also gives yet another terminology, agents and pleaders. Therefore, pleaders are also independently recognized. The moment you identify as a pleader, who is a pleader? The pleader definition includes an advocate or any person similar. The statute is that of 1908. In those days, we did not have somebody called an advocate. Therefore, probably the name had not come in. The court takes in the term pleader because those days it was pleaders who used to appear. It was the Pleaders Act. Therefore, the third is who are recognized by this code of civil procedure as competent to represent a party's grievance before the court. Now he is presenting it. How are you presenting it? You are presenting your grievance by way of a plaint. That's what I said. The first stage in the trial starts with presentation of a plaint. Now for presentation of a plaint, when you try to do this and if you face or come across with this kind of an issue that I am not there to present, you will certainly look for a solution. You will find in 3. What am I supposed to present? You will automatically understand. You will go through 2 and study. And as against whom all I should be presenting, who should be on my side when I file a suit? Should there be more people on the plaintiff side? Who all are necessarily to be before the court? Is what actually Order 1 says. Who should be a plaintiff, who should be defendant, who all should be joined as plaintiffs, who all should be joined as defendant. I'm just rushing through all these things. My importance, the importance that I would give to these specific provisions are Order 4, as I mentioned. Order 4 is the first stage in commencement of a trial, presentation of a plaint. From there onwards, if a lawyer's assistance is taken, he will understand the provisions of Order 4, and in order to make it non-defective or perfect, he will go through Order 4 and understand that he has to comply with Order 6 and Order 7. Now, Order 6 generally speaks about what all things should be looked into when you're preparing a pleading. And more specifically, it says that a plaint is more detailed, is detailed in or described much more under Order 7. It also gives a very good hint, which seldom is noticed by the lawyers, unfortunately, but I want all my young friends to look at and start in this kind of a modality so that you don't even make a mistake. I have seen young lawyers going into a case bundle room, looks for an old case which was almost similar to this, which was drafted by somebody else, and they try to copy it. And if you have not, if your whole office is going to be doing it for the first time, you go to the next neighbor lawyer who has probably handled this kind of a case, and you become a good copyist. Instead of which, you can actually go to the authority called the court, and it says under Order 6, Rule 3, please note it, Order 6, Rule 3, that every pleading shall be, as far as possible, in the forms provided with in Appendix A. So the first appendix, Appendix A, talks about pleadings, which is general. Therefore, since it comes under Order 6 and pleadings should be in such prescribed forms, Appendix A gives the first set of forms which are for the plaint, and it gives a second set of forms which are for the written statements. Is that fine? True. If you go through that, Appendix A, you will know how to draft a plaint even without the assistance of anybody else. And if you start drafting it yourself, you will find the plaint that you have drafted is only 5 pages, while the one that you have taken for copying has 8 pages, because the form tells you or teaches you how to draft a plaint in a very precise, concise form. And CPC says the pleading shall be as that of facts in a very concise, precise form. So use it. Then the order rule, order 6, rule 3. Can I have order 7, rule 1? Now I said automatically you will go into this. But for convenience, I'll just give you order 7, rule 1. Somebody is helping me to get it loaded. Yeah. If you have, can you just keep it this way? Order 7 rule. If you can just have your text open and go through order 7, if you can take order 7. Yeah. Did you get it? Excuse me, Arjun? Hello?
Sir, we have got that. You may proceed, sir.
Yeah, fine. Okay. If you can just go through the C, the plaint shall contain, order 7, rule 1 gives you almost all those, it's an index of what should be there. And then from there onwards, it says there are few other things. If it is a money suit, it's a slightly different one. And it will not be very difficult for you, because if you have A, there are forms specifically for money suits. There are specific formats for other kind of, practically for every kind of suit, you have a form. Like if it's an injunction suit, if it's a redemption suit, if it's kind of any of those, or a specific performance, all these have specific forms and which would only require your details to be filled into it. It becomes easy for the judge to read the minimum and understand exactly what is required of him to understand. Now let us just go through this. Plaint shall contain the following particulars. The name of the court in which the suit is brought. Where will you go? You will go to the preliminary in the CPC, which says you shall go to the court of lowest jurisdiction. Is that fine? The lowest court which has the jurisdiction. Suppose if it is, for example, in Kerala, if you have a suit and if the suit has a value of more than 10 lakhs, the court which can handle any matter above 10 lakhs is the sub-judge, and a municipal court cannot handle it because its maximum jurisdiction is 10 lakhs. Therefore, municipal court will not be the court, it will be the sub-court. And if it is below 10 lakh, you cannot go to a sub-court and file that suit. You will certainly have to come to a municipal court and file it, because that's a court which has got the lowest court which has got the competence or jurisdiction to handle this. So you get that. Automatically you trace this, you learn this. This leads you to the right point. The second one is the name, the name, description and place of the residence of the plaintiff. Certainly who are the parties to be taken into the proceedings. You will, and your brother, if you both are joint owners of a property, and if there is an issue with the property, certainly you will add, both of you in fact. So what are the things to be given? The nature in which this is to be given is also given in the prescribed forms. 3, the name and description of the defendant, etc., etc. Where the plaintiff or the defendant is a minor. Now look at the situation. Now you start realizing, oh look, the owner is actually a minor. And therefore, what are the things that are required to be done? It gives you the hint. There are also orders which speaks about suit by or in the name of a minor. You will immediately look at that. It gives you a warning that if it is a minor, then it's a little different. You will have to certainly do a little more of research on this. It gives you a hint, a direction to look at it. Then, unsound mind. Yes, there is yet another provision. Now, it gives you a hint that if it's a person with unsound mind, and then or some kind of an infirmity, and then you will have to work it out in that way. It makes you go in search of that. The next one, the facts constituting the cause of action. What do you mean by cause of action? The cause for your legal action. Why have you come here? There must have been some incident. There must have been some situation which has made you aggrieved. It is what is causing the grievance. That particular incident gives you the cause to come to the court. Assuming somebody jumps into your property, the couple of things. You have been the owner, you narrate all that, I am the owner of the property, I have absolute possession, etc., etc. And on a particular day, a particular person, that's the defendant, who is necessarily a party, necessarily a defendant, he has trespassed into my property, and therefore I am annoyed, I am aggrieved. Trespass is something illegal. He has no right under civil law to come into mine. Therefore, I need an injunction from repeated violations. If he is still holding, he has already trespassed into and he is occupying the property, then I may even say I need to recover the property from his side. Fine. So that will be a recovery suit. You will find a plaint for recovery of possession of property. All those formats are given. In that, you will find all these things. So if you take the right form, it gives you a lead as to what all things are to be looked into. You will automatically go into the substantive law as to what is required to be established. Your ownership, your right is based on ownership. So which is a law relating to ownership of property. So the Order 7, Rule 1 has to be understood by you and everything has to be given. Now it says verification is required and that verification model is given in your straight form. All that is available. Fine. Now, so I told you two things. One is don't ever forget Order 6, Rule 3. Try to take the appropriate form. If it is not available, take a form which is almost similar to that of this particular type of case. When it comes to this, you may ask me a question, sir, are the forms only in CPC? I would say no. You will have to look at section 122 of the CPC. That speaks about the orders and the various rules under it. It also gives the right for the High Court to form further rules, additional rules, in respect of each of the subject, for the purpose of the courts which handle or courts which are subordinate to that particular High Court. These are called the civil rules of practice in certain states. Some states, they call it as a civil court manual. So you'll have to check what is the name that is used in your state. In Kerala, it is called the civil rules of practice. Civil rules of practice has given even further forms, a slightly more detailed version. So which means that gives you a further hint that, or it makes it easier for you. That's a companion for you. It gives you an example as to how you should be drafting it. So therefore, Order 4, you present a plaint which you comply with, which complies with Order 7. Not only Rule 1, there are several rules. Yet another rule is Order 7, Rule 14, which says all those documents which you rely on are to be presented along with the plaint. Now, if you don't present it, how are they supposed to be presented? They are supposed to be listed and presented. Originals may be presented, need not be presented, because it says the originals can even be presented just before the stage of issue, a subsequent stage. But most of the lawyers, what they do is they present the originals also. Now, if you are frightened, if you are afraid that the original may be tampered with, or there are provisions, you can even give these original documents. Okay, then I'm sorry. I think, yeah. So that is Order 7. Now you comply with Order 6 and Order 7. You present it perfectly well. The suit is commenced. What was the next one that I have mentioned? I had mentioned that at Order 10, the court inquires, elucidates information. Now, what does it do? I'll just take you to order 10. Order 10 says, ascertainment whether allegations and pleadings are admitted or denied. There is a good reason. A fact which is admitted by both sides need not be proved any further. Now, if the opposite side admits all those facts, and on the facts, if the judge is capable of giving a decree, please, I just want you to attend. On the facts which are undisputed, if the court is capable of giving a decree, it can certainly pass a decree on the basis of an admission. This is provided under Order 12, Rule 6. It's called a decree on admission. So it is to enable the judge to pass a decree in the first stage itself. Under Order 12, Rule 6, that the judge would initially itself, when they come on the first day, he will ask as to whether either of the parties are admitting the claims or the other side. Suppose the plaintiff admits certain things that the defendant says, and if he admits that he is not entitled to relief number 2, he would certainly be knowingly, consciously would be waiving the second relief. The judge need to give only first relief in his favor, and on the basis of the defense which has been admitted by the plaintiff, he would refuse the second. The court can conclude the suit on the first day of appearance, which can be within about 45 days. 1. Then, that is one way of getting information. Then at 2, Order 10, Rule 2, the court can ask any kind of questions with respect to this. It says he can examine the party, and it requires any knowledgeable person or person who has knowledge of the particular facts to come and narrate the case. He on the first day understands how complicated this is, how simple this is. If it is a simple matter, he would immediately give a priority because he can finish it off at the earliest. If it is a very complicated matter, he knows that it is going to take time, so he gets a fair idea. Now, under Order 18, I told you that somebody has to present and prove his case. The question is, do you have to wait till the last stage of Order 18, instead of which, can you get all those information brought before the court even before the first day of appearance? As a practice which I follow, what I do is, I immediately go to Order 11. Order 11 is discovery and inspection. Young friends, let me tell you one thing. It gives you 3 kinds of techniques. One is, whatever you need him to answer for you to have an excellent case, you can start asking questions to the opposite side. Asking questions in writing or otherwise is called interrogation. Don't go by the other word in the criminal law. That interrogation is normally done by the lawyers. It can be done very, very diplomatically, very, very dignified manner, in a very dignified manner. So you prepare a set of questionnaires which are to be given to him. You give it to the court. Court will check whether on your pleadings or the facts of the case, whether these questions have relevance and the answers are also relevant for the judge to understand the case better and to decide. So the first set of technique is serving interrogatories on the other side. This can be done on the day on which you get a written statement. If he denies, you can, therefore the process can be started much earlier to the first day of appearance itself. 2. The second one is, you know that there are lots of documents which he has. He has mentioned in the written statement. You want to examine all those documents. Now you examine those. How do you do that? You can file an application for protection of the document for the purpose of inspection or for inspection of those documents at the place where they are. And the court would normally permit you to have that if the other party does not voluntarily permit you to inspect. Now, how do you do that? They're all very simple forms. These forms are all given within the code itself, Appendix C. You can use any of those particular forms, fill in as to what exactly is required, and you serve it on the other side lawyer. Normally, they would certainly oblige, because if they don't oblige to permit you to inspect the documents, you can certainly make an application to the court, and the court would also think that the other side is a bad guy, that he is not cooperating, and the court would certainly permit or give an order or a direction to the other side to permit you to inspect. So the second technique is inspect those documents, what he refers to in the plaint or in his written statement or the plaint. Now, once you inspect those, you get a few leaves, because those documents might refer to certain other documents, certain statements, etc., etc. In which case, what you can say is, you can file an application under Order 11, Rule 12. I'm not going into details because the time may not permit me. It's such a vast subject. Now, when you make an application under Order 11, Rule 12, I would call it as Order 11 application, because each rule probably would take a lot more of time for you to understand. Now, under Order 11, there is a rule called Order 12. Once you apply for direction to produce all those documents which the opposite party may intend to rely, or he may rely in the suit. That means you are getting all those in the initial stage itself. This can be done even at the time when you present a plaint, so that when you file a plaint, you can file certain applications like asking him to present all the documents, or the written statement. Even before you prepare a written statement, you can file an application to the plaintiff's counsel stating that the plaintiff shall produce all those documents which he intends to rely, which means I can prepare a written statement after perusing all that, and the court would normally order this. Therefore, this is a technique whereby everything has become so transparent before the court. Every material has actually come before the court, and court can look at it. You don't have to wait till the last day to cross-examine him, grill him, and then get all those information. These all come before the court. Therefore, one is ask questions, interrogatories, get answers before the court to the extent that you need. Ask him to disclose all those documents, disclosures, all those details of the documents. You can even inspect them after they disclose. Once you find some of them are relevant, you can ask them to produce it. So you get those documents also before the court. Inspection, a request for production, a request to answer by the other side. These are called discoveries. Discover means what is kept covered is being exposed. If the other side does not comply with it, then there are negative sanctions under Rule 23. So, my friends, if you go through Order 11, you will find the kind of techniques that are given to you. And also it explains how simple they are to be exercised. The forms are given. Suppose if you are asked to expose your details, how it has to be answered. Everything is so very clear. Is that fine? Now, all these things are here. I have documents. I have documents with me. I have statements with me. I have a case pleaded. What do? I want the other side to admit all those documents which are placed before the court. Fine. All those documents which are placed before the court to be admitted because they are important to me, they are relevant to me. And he is supposed to do that within a prescribed time of 7 days or 10 days, etc., as provided under the code. So Order 12, if you look at the heading itself, Order 12 speaks about admissions. Admissions means, one, a party may voluntarily admit at Order 10, Rule 1, either by way of his written statement or before the court. Thereafter, if he doesn't volunteer to admit, I can even force him to admit or deny specifically. The advantage is, to the extent he admits, I don't have to worry about myself. I don't have to have an heart attack on the last day because I could not perform so well. Everything comes much, much before itself. Then, therefore, that becomes admission. Now, I make a statement. I am the son of so-and-so in a partition suit. And he denies it. If he denies it wrongly, then there are negative implications like cost, etc., etc. All those things are there. Now, if I make the statement, if I ask him to admit this, he normally would admit. To that extent, I don't have to produce any further document. So I am the son. Then I say there are 8 properties which are available, which were available to my parties at the time of his, which were available to my father at the time of his death. If they admit that, excellent. I don't have to prove those further through documents, calling witnesses, etc. So that also remains admitted. Now, this is the way you get admission of my case. So I can get my case admitted. I can also get one of those documents or some of those documents which I have produced admitted, which means I don't need to get a witness for proving these facts. Now, in this manner, if I can get all the case, all my versions admitted through the other side, then under Order 18, I only need to file an affidavit and tell the court, sir, this is my case. And my case is actually admitted by the opposite party through the affidavits which he has already filed when I invoked Order 12. So that is also possible. Order 18 becomes insignificant to a larger extent. So this is the advantage of admissions under Order 12. Seldom people file these kind of an applications. Now, young friends, let me tell you one thing. Today, there is a difficulty of a junior lawyer versus senior lawyer. Face values. All these are there. It's a realist school of jurisprudence out here. Now, as youngsters, if your documentation is perfect, even a senior face probably would be irrelevant to the court because you have documented things perfectly. You have time to study. Faces don't matter at all. And these kind of practices are not much followed by the seniors. So in such a situation, you have already done your homework. You have presented the case perfectly well. You have got his client do all those things. The role of the senior in the court in these kind of matters becomes very, very less, except to the extent of arguing as to how the law applies, which you can also do a good research. You have been doing it in the moot courts, work it out so well, and you may have excess time. Seniors may have an excess experience, compensated by extra work, present these. So these are the two. Now, if these things are admitted, then the next stage is basically issues. Issues is the court has to look at what are the disputed matters. Now, once you exercise all these kind of techniques, hardly 20% would remain disputed. Or there's a chance that most of these things are admitted. Sometimes cantankerous parties may not even permit such an admission, which means you have to worry about it, and the court would ultimately give you a much larger cost if he has been absolutely dishonest to the court. Now, in the issues, if most of the facts are admitted and there are certain questions, or there are certain matters which would go to show that the court would not have the jurisdiction, then Order 14 Rule 2 says that such a suit has to be disposed of at the first stage itself. That is, immediately after framing issues, the issue relating to jurisdiction, which means his competence to go further, has to be decided. And only if he finds that he is competent to decide or he has got the jurisdiction to try this particular suit, he needs to proceed with. Otherwise, it becomes a wasteful effort of going with the suit till the last stage. It wastes the court's time, it wastes our time, and it would also take a second round of litigation at the proper competent court. Therefore, some suits are dismissed at the initial stage on the grounds of lack of jurisdiction, lack of maintainability. Now, assume that everything is maintainable. All the facts have been placed before the court, and the parties say, yes, there are documents to prove every point, and the parties say there is no necessity of an oral evidence being adduced because the documents themselves conclude the evidence. Then the court can at once hear the matter because there is no oral evidence required. Facts being admitted, the documents being admitted, the effects of the fact and the documents with respect to the law applicable alone need to be considered. Just look at Order 15. The heading is what? Disposal of the suit on the first day of hearing. Think of this. The first day of hearing happens almost in 45 days' time. on that day or by which date, if you have already invoked order 11, order 12 techniques, order 10 has also been exploited by the judge properly, then there probably would not be anything much for the oral evidence, which is actually, which alone actually attracts order 18. On order 15 stage, in the first day itself, we can certainly have the matter argued. Therefore, my friends, you will certainly read order 15 and check what is required for getting a disposal on the first day of hearing. Order 15 different rules clarify as to in which situation the judge can conclude the matter on the first day itself. Now, if you are looking at the modern trial, modern trends, this is something which would be very important for all my young friends. Is that fine? And to achieve that kind of an effect of getting all the documents placed before the court, invoke order 11, getting all those information, that is verbal information by way of admissions, etc., etc., have the interrogatories, questions got answered by him. And if he gives those answers which are in your favor, those are available. Secondly, all those admissions under order 12, they are also available. All these are sufficient to get a decision in order 15 stage. Order 16, unfortunately, has been placed subsequent to order 15. I'll tell you why. If things are not disposed of, on consensus or admission, etc., etc., and parties literally go forward saying that no, we would like to fight it out, then alone a third party would be summoned, because he would be examined under order 18. Now, if the third party can be, or if the third party is required to produce a document, then such party can be summoned for production, or he need not even be summoned. He can be summoned only for the purpose of causing the document to be produced, which means he can even make it available before the court even without the party coming. So that is the case. At the earlier stage itself, if we can take the steps for getting all the third party documents without waiting till the order 16 stage, then even those documents can also be put to admission. It can also be got admitted through order 12. All that is possible, and order 15 stage can be invoked at that level also. Assuming nothing happens, and if you have to fight it with swords, with your army, then all these people who are summoned as witnesses are your army on each side, which can be avoided if you take appropriate steps. Order 17 is adjournment. The court would have been in difficult situation if it did not have the authority to adjourn the case from day to day. It will have to complete the whole thing on the same day itself. So adjournment under order 17 is also a provision which is contemplated under the court. It is a necessity. Order 18 now comes in effect. Having everything got admitted, having all the documents got produced before the court, and when both the parties say, no, we don't need a witness to prove those documents because each one of us understand the content, we are not contesting it, contesting the genuineness of the document, order 18 gets limited to the summarized hearing which takes place in order 15 stage. Is that fine? And once that is over, then it comes to order 20. Now you will ask me, what is order 19? Order 19 speaks about affidavits, as to what is the manner in which affidavits have to be filed. Affidavits are filed in interlocutory applications and also as proof, as in the evidentiary stage. In the evidentiary stage, when somebody is filing an affidavit, such an affidavit contains only a fact, and it is stated only by a person who has personal knowledge about it. But assuming it is an interlocutory application at the initial stage where the court goes on a prima facie satisfaction, you can also say, yes, this is a fact which I narrate or which I swear on the basis of information that I have, my personal knowledge and belief, which would not be available if you are filing an affidavit in substitution of a chief examination or other examinations. Now, I would just like to summarize order 1 to order 20 for your better understanding. Order 1, parties are firstborn, therefore parties come under order 1. Thereafter, they develop their own cases or a frame of mind wherein they have a particular case to put forward. That is the frame of the story that you put forward, which comes second. Somebody has to narrate it. If not me, who else can? It provides for an authorized, recognized agent. 4 is presentation of such a plaint having all this a framed case before the court. How do you present it? Present it, complying with 6 and 7. Thereafter, court would issue a summons, and court is given formats as to how the summons should be. There are 3 different stages. I may have to skip this because it goes a little more advanced. There are 3 different kinds of summonses which you can see from summons form 1 to form 3. Each has a different purpose. It also helps you speeden up the trial. Once the summons is issued, it says you are supposed to file a defense. That defense is contemplated under Order 8 because pleading says written statement, rules of written statements are under Order 8. 9. After this, you are supposed to appear on the first day. Order 9 speaks about what happens if you don't appear, what happens if one party appears, the other party does not appear, and if the plaintiff does not appear, court can even dismiss it for default. When the defendant doesn't appear, the court can even go ex parte and give a judgment, provided all the other materials are available, or it can even adjourn to facilitate the parties to come. When both the parties don't come, it will be treated as if the party is not interested. When both the parties come, you go to the 10th stage, Order 10, wherein both the parties are informally asked to, explain it to the court, prima facie what exactly the case is. He would also get, inquisitively, he would also get clarifications. Once he gets clarifications, he feels that there are so many things which are relevant to this. There are documents, there are answers to come. People can invoke Order 11. And once you get all these things before the court, you can also get them admitted through applications that you file for admission of facts, your case, or the documents which are available to avoid the strenuous task of proving it at Order 18. So if you do that in Order 12, then you get into the next one, which are the documents to be produced, which may not be acceptable for the purpose of further trial. Once you get all these things before the court will go through all these things, and in Order 14, it says, going through all these, the court will pose questions to itself as to what am I supposed to find out from these documents, and what are the questions which I may have to answer for arriving at a conclusion in the judgment. That is called issues. If in the issues, first question is that the court does not have competence, the court will immediately dismiss the court. Dismiss the suit itself, or it would say it has to go to some other court. Order 15 is the stage when all the materials are available, undisputed matters are available. On the undisputed facts, the plaintiff says, I would continue with this, and I would confine my relief also to my claims also to the admitted facts, etc. Then the court may even hear you on the basis of the undisputed documents, and you can have a disposal at that stage. If not, Order 16, where the court will start taking steps to get your army called the witnesses for the purpose of Order 18, and the court otherwise incidentally has power to, under 17, has the power to adjourn the matter. Ultimately, it keeps on adjourning in the courts because you are in the queue. And then when you get the chance under Order 18, the whole trial, which when you go for the court visit, as what you watch, the chief examination, the cross-examination, I would even call it a torture. When a person is asked to get into the box and he is asked all kinds of questions, irritating him, which otherwise you could have done it by way of an interrogatory. So under Order 18, the 18 stages, the trial, the 19, just an incidental proceeding, with an incidental provision which says how an affidavit can be used for the purpose of admitting, for the purpose of giving evidence, etc. And after 19, you have 20 says how a judgment should be, within how much time the judgment should be given. Judgment has to be given in 30 days in the normal course, with an extension, possible extension of another 30 days. That's a maximum of 60 days. What all things should be contained in that. Now let me just give you the appendix, which are going to be the guiding factors, the examples for you. A for advocates means A has the formats required for the lawyers, which are plain and written statements. When you go through that, you will get it. B for the bench means for the judge, That gives you all kinds of documentation, the summons, etc., which a judge alone alone will need. So B for bench, that helps the judges for getting all the formats. C are common. C relates to, so B would be certainly with respect to order 5 summons. C are meant to be used in order 11 and order 12, etc., which are meant for both. You may make an application, the court may pass an order, the other side may answer your queries. You may file an application for admission. Your denial on the other party's denial, what is the nature of order that it would, interim order that the court would give, etc. So 11 and 12, it is a joint effort by the judge, both the parties. So C gives you all the kind of formats which are common for bench as well as the parties. D means decrees. Decree means, it's for an easy understanding. I would say D means decrees. Decrees are the formal documentation as to which would finally state what each party is bound to do, what each party is not bound to do. This is what is the final decretal clause, and that is well guided through Appendix D. Now assume after all these things, the party, after getting a judgment, knowing what is supposed to be, doesn't do it. Then you have E for execution. Execution means enforcement. Enforcement has the word force. Judge would forcefully make the other person do if he does not do it. Now you have E, F, G, H, etc. up to I. These are all relating to incidental proceedings and supplementary proceedings and other miscellaneous forms. So my dear friends, due to the time constraints I have, I believe such a vast subject I have been just summarized for your advantage, and I would be the happiest person if you have got at least 40 to 50% of what I have mentioned, and if it helps you to understand what you should be looking at when you're going in for actual trial practice. Thank you very much. This is with respect to, this particular topic is with respect to civil trial alone. Now, today you have a different class of subjects called the commercial courts, wherein also you have the CPC, but that has become a little more cumbersome and a little more strict on the judges as well as the courts in order to reduce the order 18 stage. So that would be a little different. I have not touched upon that. They are slightly different, so don't get confused. When you go into a commercial court, please don't use exactly the same thing. 90% of this would remain the same, but there are certain variations under order 11, order 12, etc. There are lots of provisions, order 7. All these are, subject to change in that. So keep this in mind, and thank you very much for your patience. Thank you.
Thank you, sir. Thank you, sir. Thank you so much for your words of wisdom. We, on behalf of Bharat Mata School of Legal Studies, really thank you for taking out time for us. It's been our pleasure to have you with us. Thank you so much, sir. It has been a very informative session for all of us. Thank you, sir.
My pleasure. My pleasure.
So, taking our session further,
Warrior, sir.
I would like to inform.
Yes.
Yes, sir.
Warrior, sir.
Somebody.
Just,
Yes, sir.
I just request you to tell the students.
Yes, sir.
See, your presentation academically excellent. In 2 hours,
Yes, sir.
you could do wonders. From my personal experience, I would say
Yes, sir.
chief examination through advocate commissioner.
Yes, sir.
Now, I have seen 4-page, 5-page chief examination and 300-page chief examination. So after reading the chief, this one, judge is confused, totally confused. He has to go through 300 pages. It would have been better if the PW1 was directed to be present. Now, one thing. Second one, interrogatories.
Yes, sir.
I've seen your senior Govinda Dariya preparing interrogatories, P. Sukumaran Nair preparing interrogatories.
Yes.
But today, in the last 10 years, I've seen some other type of interrogatories framed without imagining what would be the answers. And when the answers come, they are in more trouble.
Yes.
Because they are not asked pertinent questions. So there is one thing, and that leads on. And then third aspect is presentation of documents, that is summoning documents in the present state. So
Yes.
if time permits, 2-3 things also would be wonderful.
I would certainly, if you can permit me 5 minutes, I'll probably conclude it, sir.
Okay. Thank you, sir. Thank you.
Friends, I'll just take you to one thing. I specifically mentioned Order 18 and 2 words. Party states his case. A witness deposes what he knows. When the party states his case, he states it through an affidavit. But understand, he states his case, half of which he may not even know. That is the reason why you have to substantiate it through a person who has direct knowledge of that one. Because the witnesses are not stating the case. I always say that under 18, the judge just wants to hear from the mouth of the party. In that kind of an affidavit, it becomes a descriptive one. But don't describe irrelevant things. Even the plaintiff also very specifically, if you go through the formats, I'll just give an example. A suit for specific performance requires only 7 sentences. If you follow the form, which is 47 and 48 under Appendix A, 7 sentences and you can still get a decree. Whereas in a suit for specific performance, you will find 10 pages. And the art of confining this to the 7 sentences is what advocacy is. But unfortunately, today's trend is that the fees is based on the number of pages, and the clients also feel that unless we write so much, they are not, the lawyer has not done the work. But as far as you are concerned, please take this message, go through the forms and see how concise and what the judge gets. Now, when you convert this into an affidavit, you have to only plead so much. Even you may not even plead all that. Now, in the affidavit also, if it is a statement by a party, the way I normally write is, as admitted is what I write in the affidavit by the party, because party is not proving it at that stage, except to the extent of things that they know. Now, assume that you have summoned a witness to state. He may be stating only one thing. You need to state only that particular one sentence or sentences which would describe that particular fact which is supposed to be proved through him. You don't have to take it. Now, there are certain very, very complex litigations where number of issues are so many and number of facts to be stated are so many. In that, you may have to give a descriptive affidavit, which probably you can't avoid. It depends on the case. But 99% of the cases are based on short facts or limited facts, which can be pleaded in very small affidavits. One, by unduly detailing it with irrelevant matters, the judge only gets annoyed. He is not going to be happy with you. Your job as a lawyer is to assist. You are to assist the judge. That is what the primary obligation that you have as an advocate. Of course, without compromising the interest of the party. Now, by doing it in the simplest way, if you do not compromise with the interest of the party, there is nothing which prevents you from following the golden guidelines that the CPC itself gives. Now, you have to focus on what you need as a document. You normally ask for an inspection of documents first. And you inspect the documents. First is the disclosure. In the disclosure, they only give all those details of the documents. They don't come before the court. You ask for an inspection of the document. You go to their place, don't even get these documents produced before the court. You go to their place, get it inspected. Now, if you find something really significantly relevant to you, file an application only for production of those documents, streamline the documents that would reach the court. That is what the second one would be for the query. Interrogatories. Now, he had taken certain names. We were fortunate enough to be under some of the seniors. There is a word called Swayambhu. I don't know if you have heard of this. Swayambhu means somebody just comes up. Or, please don't be that. Once you read all these things and you feel that I am well guided by CPC, but there is some kind of an experience that the seniors have. in not doing certain things and doing things. So do all these things, but be sure that for substantial number of years, you go and get guided by one of the finest lawyers whom you choose at the initial stage itself. So these are the probably three things that I would like to advise you. I did not have the time to elaborate, otherwise I would have given you a little more code class and other things. Today's purpose, I believe, is served within the 2 hours that is allotted to me. Sorry, Shashi sir, if I have not been able to do fully.
No,
I
it
mean,
will
just
take long. I know that because I thought to make it more comprehensive, some practical side, especially in this area. That's why I suggested it. Thank you. I know it's very
Thank you,
difficult
sir.
because not.
Sir,
Thank you.
okay, we apologize,
Thank
sir,
you.
because of the
Thank you very
time restraint that we have on our side. Thank you, sir, but
Please.
you have done an excellent job, sir. Thank you so much, sir.
Please go ahead. Yeah, fine. Thank
Okay.
you.
So taking our session further, I would like to remind you all that the question answer session, due to a time constraint, will be extended to a situation where you can ask questions and all the queries will be dealt via mail. So we request all of you to send us all the questions, and the questions will be responded via mail. Now moving forward, gaining knowledge is the first step to wisdom. We all know that. But sharing knowledge is again a step to humanity. So as the advocates of tomorrow and a helping hand to humanity, I would like to invite our student presentators, Ms. Ahasana and Ms. Seema Sebastian, to present on the topic Res Judicata in India, an issue and service of summons in civil and criminal cases. Over to you, Ms. Ahasana. I request our student presentator, Ms. Ahasana, to proceed with the session further.
Good afternoon, all. Can you see my slide? Am I audible?
Yes, Ahasana, you may proceed.
Hello, am I audible?
Yes, you're audible.
Thank you everyone for being here today. I would like to thank you for giving an opportunity to present. The topic that I'm dealing today is res judicata. It is one of the most important concepts in all civilized legal system. Res judicata is a Latin term. The word res means subject matter and judicata means adjudged. So together, res judicata means a matter adjudged or decided or a thing or matter settled by judgment. This concept is based on public policy and has universal application. All civilized legal systems have as of this doctrine. India found its evolvement from English common law system. From the common law, it got included in the Code of Civil Procedure 1908, which has later adopted by Indian legal system. Justice Das Gupta, in the case of Satyadan Ghoshal versus Darojin Devi, has explained the doctrine of res judicata in the most simplest way. The principle of res judicata is based on need of giving and finality to judicial decision. Primarily, it applies as between past litigation and future litigation. When a matter, whether on question of law or fact, has been decided between two parties in one suit or proceeding, and decision is final, and neither party will be allowed in the future suit or proceeding between the same parties to canvass the matter again. The embodiment of principle of res judicata is necessary in order to give finality to litigation and prevent a person from being dragged to court again and again. This concept is based on three maxims. First one, nemo debet ex vexari pro idem causa. No man should be vexed twice for same cause. Second one, in res republica ut sit fins litium. It is the interest of the state that there should be an end to litigation And third maxim, res judicata pro veritate acceptor. A judicial decision must be accepted as correct. The second and third maxim is a reflection of public policy and first maxim is a reflection of private justice. Whether res judicata or section 11 is exhaustive? Section 11 is not exhaustive. The general principle of res judicata can apply everywhere. For example, writ proceeding principle may apply. Suppose, in case of tribunal, section 11 as such may not apply, but the principle will apply. To raise the plea of res judicata, it is not necessary that the plea must fall directly within four corners of CPC, as long as it can be raised on the general principle of binding nature of final decision between the parties. The doctrine of res judicata is founded on the principle of equality, justice. This was held in the case of Lal Chand versus Radhakrishna. Now, is res judicata technical? See, the decision can be rendered on merit as well as on technical ground. What will happen when appellate court rendered a decision on technical ground? Let me explain with an example. Suppose a suit based on promissory note. The defendant put two contentions. The promissory note was not executed by him. The suit is barred by the limitation. The trial court found that the promissory note was executed by defendant and suit was not barred by the limitation. So the court accepted the suit. Later, defendant given appeal to the higher court and higher court not agree with the trial court and held suit is barred by limitation. So, here I am posing a question. What will happen? Whether the findings of trial court can act res judicata in subsequent suit. It will not operate as res judicata. It was held in one of the most important case, the most reverend PMA Metropolitan versus Morin Marthoma. In this case, appellate court barred a suit. Barring of a suit, its consequence is dismissal of a suit. So there is no res judicata. Now let's check out the prerequisite for applying the principle of res judicata. The first one, there must be two suits. Second one, the matter in issue should be same. And third one, between the same parties or their representative. Fourth one, competency of court. Fifth one, litigating under the same title in the both suit. And explanation 1 of section 11 of CPC explain what is formal suit. That is, a suit which has been decided prior. The explanation 3 of section 11 states that the matter referred in the formal suit have been alleged by one party and either denied or admitted by other. Let's see what is matter under the section 11. The expression matter in issue means right to litigate between the parties. That matter in issue can be direct and substantial or collateral incidental. Here the word direct means any fact directly associated with an issue, and the word substantially means the fact which is substantial for the determination of an issue, and collateral and incidental is matters that are remote to our case. Let me explain with an example. Ajmer Central Cooperative versus the prescribed authority. In this case, a suit was filed by an employee for an interim injunction restraining the management from removing or terminating him from the service, and the injunction application was dismissed. Later, he was removed from his service. After that, the employee filed a petition under Rajasthan Shop and Commercial Establishment Act, challenging the dismissal. By the time he was filing application, before that, he was dismissed and there was no interim injunction. The suit was dismissed for default. The prescribed authority. The second application is before the prescribed authority, and this prescribed authority held that dismissal was illegal and ordered reinstate. The case went to Supreme Court. The management contended that order of civil court act as res judicata before the prescribed authority. However, this contention was negatived, and it was held that observation decisions were never final and meant to merge back for a final result. that in this case, the trial court dismissed a suit for default. A dismissal of a suit for default is no decree under any law. So there is no direct and substantial issue in this case. So there is no res judicata. And next one, explanation 4, which deals with constructive res judicata. The constructive res judicata is artificial form of res judicata. In the case of Ghanshyam versus Jaiswal, in this case, the judgment debtor under section 47, an application was filed challenging the validity of compromise, which was rejected by the executive court. Later, he filed another application under same section, that is section 47, contending that decree is vague and incapable of being executed. So, here arises a question is that whether we can apply res judicata, because he raised different contention. In first application, he said that he challenged the validity of compromise. In second one, he contended that it is vague and incapable of executing. So, different contention. Here whether we can apply the principle of res judicata. Yes, we can bar this suit by the constructive res judicata. The explanation 6, it states that a person litigate bona fide in respect of public right or a private right claimed in common for themselves. Other all person interested in such right shall for purpose of this section deemed to be claimed under the person litigating. Suit brought or defended by one person or more person on behalf of themselves and others with the leave of the court under Order 1, Rule 8 are common instance of this class. In 1986, SC 391, in this case, 3 judges, it was held that Section 11, Explanation 6 applies to PIL. PIL means public interest litigation. But it must be proved that the previous litigation was PIL and was not a private grievance, and it has to be bona fide litigation and with respect of right which is common. And explanation 8 deals with the competency of court. It is essential for res judicata to operate against the subsequent, that is, that the former suit should have been decided by the court competent to try the subsequent suit. The expression competent to try the subsequent suit if brought at the time the first suit was brought. Before explanation 8 was added, the position was that the court which decided the former suit must have been competent to decide the subsequent suit as well. If it was not there, then res judicata would not apply. With the insertion of explanation 8, we can apply res judicata even if the court which decided the former suit is not competent to decide the subsequent suit. In some case, there can be certain issues decided by the court. In such case, the second court shall not decide these issues that were decided by the first court in the former suit. In such case, res judicata will apply not to the subsequent suit, but those issues therein which were decided in the former suit. Of course, yes, there is some exception to the res judicata. The first one, judgment in original suit is obtained by fraud. Second one, when a special leave petition is dismissed without adjudication or decision, then res judicata should not apply. Third one, interlocutory orders is the interim orders passed by the court. Section will not apply, section 11 will not apply. It is because interlocutory orders is immediate relief. When there is a fourth one, when there is a change in law, then no law brings new rights to the parties. Then such rights are not barred by section 11. In the end of this presentation, I would like to put some of my thoughts that there should be an end to the litigation. The matter or issue decided by the court collaterally, the doctrine of res judicata should be made applicable. And also, still the application of principle of res judicata in writ is a debating topic, which will be made more clear. Thank you.
Thank you, Ahasana. Now I call upon Sinu Sebastian, our next presenter on the topic. issue and service of summons in civil and criminal cases. Over to you, Sinu.
A very good afternoon to all of you. After a wonderful presentation by my friend and fellow colleague Asana, I would like to speak about something entirely different, albeit exciting: issue and service of summons in civil and criminal cases. In this presentation, I will be discussing about meaning, issue and service of summons and its importance in civil and criminal jurisprudence. The purpose and procedure of issue and service of summons in civil and criminal cases comes under Code of Civil Procedure 1908 and Code of Criminal Procedure 1973 respectively. So coming to our topic, suppose a person say X wants to bring any action against another person Y. The first thing that the plaintiff do is he, along with his advocate, should submit plaint in duplicate in court, and the court will register the case if plaint is proper. This process is called institution of suit, which comes under Order 4 of CPC. After a suit is duly instituted, the court may issue summons. Ode alterum partem. It's a Latin word which means that no one can be condemned unheard. This is to ensure natural justice. So for a free and fair trial, both sides of the parties should be heard. Any decisions made without hearing one side of the party cannot be considered as a fair trial. So, court may tell the other party why about the suit initiated against him through summons. So, is there any difference between issue of summons and service of summons? Yes. When the court drafts the summoning document and it is signed and handed over to the court officer for dispatch, it is called issue of summons. When the summons is taken to the person who is being summoned, either by the court officer himself or through the post, it is called service of summons. So through a summons, the court is inviting the defendant to appear before it and answer the claim of the plaintiff. Summons is a legal document issued by the court under its stamp and signature of presiding judge. So within 30 days of issue of summons, the defendant may be directed to file a written statement. A written statement is made by a defendant as the answer and defense against the claim of the plaintiff. And the court and the competent court is also empowered to pass an ex parte decree if the other party does not appear even after receiving the summons. CPC generally deals with service of summons to two different persons. One is the defendant and another is witness. So, Section 27, Order 5 of CPC deals with the service of summons to defendant and Order 60 deals with the summons to witness. So, what is the basic idea of issuing summons? The concept of summons is to allow speedy disposal of cases. Can any paper be called a summons? No. A summons shall bear the sign of the judge or any such officer appointed by him and shall be sealed with the seal of the court. And it should be in the form prescribed in Appendix B to first schedule of the court, like it should contain the court issuing the summons, name of the person instituting the suit, date and time for appearance, etc. After the issue of summons, the defendant may appear in person or by a pleader duly instructed and able to answer all the questions relating to the suit, and by a pleader accompanied by some person who is able to answer all such questions. The problem of service of summons is of the major cause of delay in the progress of a suit. It is of primary importance as it is a fundamental rule of procedure. CPC mainly describes 5 principal modes of serving summons to defendant. So after receiving a copy of summons, the defendant is required to sign acknowledgement on the original summons. So as I already mentioned, the code describes 5 principal modes of serving of summons to defendant. First mode is serving by court, which comes under Rule 9, where the defendant resides within the jurisdiction of the court or he has an agent empowered to accept the summons shall be served by the proper officer of the court by courier approved by the court. Next mode of service is service by plaintiff, which comes under Rule 9A. The court may also permit the service of summons by the plaintiff, but there should be sufficient safeguards to avoid false report of service of summons. The third and usual way of serving of summons is personal or direct service. The court says that wherever it is practicable, service shall be made on the defendant in person unless he has an agent empowered to accept service. And in the case where the suit is in relation to business or work against the person who does not reside within the local limits, the service may be made on his manager or agent who is actually working at that time. And where the defendant is absent at the time when the service of summons is to be effected, it can be made to the adult male member of the family. The court acting under the provision can also go for a substituted service, which is another mode of service if the defendant or his agent refuses to sign or acknowledge, or where the serving officer, after due diligence, cannot find defendant and there is no agent to accept summons. In that case, a copy of summons shall be affixed on the outdoor or some other noticeable part of the house in which defendant ordinarily resides or carries on business or personally works for gain. Court acting under this provision also order service of summons by an advertisement in a newspaper circulating in the locality in which the defendant last resided or carried on business or personally worked for gain. And the fifth mode of service is service by post, and it's sent by a registered post. And it should be noted that where the defendant refuses to accept summons, he is deemed to have been served. In addition to the ordinary mode of service, there are some special cases like service of summons to defendant who resides within the jurisdiction of another court. How can a summons be served to such a person? In that case, summons shall be addressed to the defendant at the place where he is residing and sent to him by post if there is a postal communication between such place and the place where the court is situated. And the next case is how a service can be made on a defendant in prison. The summons shall be delivered or sent by post or otherwise to officer or officer in charge of prison. And the third special case is service on civil public or on servant of railway officer or on servant of railway company or local authority. In this case, summons may be served of the defendant to the head of the office in which he is employed. And the last special case is service on soldiers, sailors or airmen. It shall be sent, in this case, it shall be sent the summons for service to his commanding officer together with a copy. Several courts around the country are experimenting with usage of technology. Supreme Court held that all summons and notices are allowed to be served through digital medium, including email, fax, and instant messaging mobile application. This decision comes in the wake of a visit to the post office not entirely possible due to the coronavirus pandemic. Recently, the Delhi High Court gave an order setting a milestone which states that double tick on WhatsApp is a prima facie proof of delivery of summons. In a hearing, Attorney General K.K. Venugopal, representing the central government, told the top court that service of notice and summons should be permitted through email and fax in the view of COVID-19, but not through WhatsApp, given that messaging app does not allow government to access data, even in matters concerning terrorism and pornography. High courts have also adopted practical steps to address in the problem of delay caused to the process service by introducing changes in rules and policies. The code, that is Civil Procedure Code 1908, was amended in 2002, which included electronic means of serving summons in Rule 9 and 9A. Now, let's look into some case laws. Central Electricity Regulatory Commission versus National Hydroelectric Power Corporation Limited. In this case, Supreme Court directed that in commercial litigation and in those cases where advocates seek urgent interim relief, service of summons may be affected by email in addition to normal mode of service. In Tata Sons versus John Doe, Delhi High Court allowed the plaintiff to serve summons on one of the defendants through WhatsApp, text message, and email, and to file affidavit of service. In similar way, Delhi Metropolitan Court earlier in March this year allowed a woman to serve summons to her husband in Australia through WhatsApp. In Pal versus Kumar, it was suggested to the magistrate that the summons can be served via WhatsApp, etc., since the summons sent from the past 8 months being returned as the man is not staying at the last known address in Delhi. The court allowed the summons through WhatsApp, SMS, and email. The document submitted before the court revealed that there is double tick on the WhatsApp messages sent. So, 2 blue ticks on WhatsApp signifies the service of summons. Let's move into the provisions of summons in criminal cases. Chapter 6 of CRPC 1973 deals with the issue and service of summons upon the accused person and the witness in the criminal case. 61 to 69 are the relevant provisions, and 61 deals with the summons and remaining provisions deals with the service of summons. Like in CPC, here also summons is an order to appear before the judge or magistrate to answer the offence he has committed, to a person to show cause against some order, to a witness to give evidence. According to its grave nature and severity of punishment, criminal cases is divided into summons case and warrant case. In this case, summons is issued to the accused person and it is enabling him to surrender before the court and give any explanation regarding the suit which he deems necessary. In warrant case, a magistrate may issue the summons in warrant case to allow the accused to appear in lieu of arresting him and forcefully producing him before the court. Next comes the fact that who can serve summons. Usually, summons in criminal cases is served by a police officer or by any officer to such rules as government may prescribe. And there are certain essentials that should be satisfied before sending a summons. And every summons issued by the court under this code shall be in writing. It's a must thing, and it should be in a duplicate form, and it should be signed by the presiding officer of the court, and it shall bear the seal of the court. Like in CPC, here also there are mainly 5 modes of services of summons. The first mode of service is personal service, and it is served to the accused by the police officer or by any officer to such rules as may prescribe. Second mode is service of summons on corporate bodies and societies. It comes under section 63. To whom that summons can be issued? The secretary, local manager, or other principal officer of the corporation. And how it can be sent? By a letter, by letter sent by a registered post addressed to Chief Officer of Corporation in India. The next mode is service when person summoned cannot be found. Missing person. It is dealt in section 64. When it can be issued, even after due diligence to find the person and fail to find him, alternative services is by leaving one of the duplicates for him with some adult male member of his family residing with him. A servant is not a member of the family within the meaning of this section. And the next is service on government servant. It comes under section 66. When can it be summoned? The person summoned is in active service of the government, and it should be sent in duplicate to the head of the office in which such person is employed. Acknowledgement is returned to the court under his signature with endorsement required by that session. Such signature shall be evidence of due service. The last mode of service is service of summons outside local limits. It shall ordinarily send summons in duplicate to a magistrate within whose local jurisdiction the person summoned resides or is to be served. And last one, section 68 deals with the proof of service in such cases and when serving officer is not present. In that case, the serving officer can prove it by an affidavit or presenting the duplicate copy with a signature signed by the defendant. So coming into the conclusion, several courts around the country are experimenting the usage of technology and in judicial proceedings, especially while serving of official documents. The electronic means list of all WhatsApp are not going to replace the regular models. They are only meant for those experimenting cases where defendants are hiding and evading their appearance in a court. That's all about my topic. Thank you for your patient listening, and you can mail your doubts if any, and we will be clearing it. Thank you, and have a good day.
Thank you, Senior Sebastian. It was a wonderful job. Now, we would like to move on to our next session, that is the question and answer session. I urge all the participants to kindly drop all your queries into the chat box so that our Chief Guest, Advocate Sriral Warrior, can answer the questions. I request our Chief Guest, Advocate Sriral Warrior, to kindly clear all the queries regarding the session.
It would be nice if they can confine it to the topic. I found some assignments to be forwarded. Hello.
Yes, sir. Yes, sir. We can hear.
I found some of their assignment questions to be forwarded. You know? So,
Yes, sir.
if possible, ask them to confine it to the trial portion, because that is anyway. I have no objections. Anything can be asked.
I request all the participants. This is a question answer session. You can feel free to ask any questions regarding our session. So a question that has been raised by one of our participants was, the question was raised by Megha Mavan, that whether an appeal against final degree correctness of the preliminary degree can be questioned, whether no appeal has been preferred by aggrieved party against the preliminary degree.
Generally, it is not supposed to be.
Okay, sir.
Because there are two different proceedings. One, the consideration is certain things as to who are the parties and what are the properties. In the final degree, the question is allocation of the otherwise confirmed assets among the confirmed parties. Fine. So whether the allocation is right or improper, inclusion, exclusion, these are the questions which are normally checked in the final degree. While in the earlier one, who are the parties and what are the properties available for partition. Okay.
Yes, sir.
So
I hope the doubt
is
is clear.
Yeah.
Yes, sir. So the next question, which was raised by Adira Babu, was that in a civil proceeding, whether a degree is silent as regards to the future interest, whether the future interest shall be deemed to have refused a separate suit shall lie or not.
See, interest is covered by section 34. Okay.
Yes, sir.
This is provided basically for it's a negative sanction against delaying tactics, and whoever has actually come for the relief should not be prejudiced by delay. So therefore they get the interest. But to the specific question, I think the provision itself is very clear. It is deemed to be silent. The court has refused it. I believe it must be section 34(2) or so.
34. Okay.
Specific provision is provided. Yeah.
Okay, sir. So the next question, which is raised by Nishma James, is that, is there any contradiction between section 27 and order 5 rule 1 with respect to time to file written statement?
See, as may be described, okay, as did you see even order, see section 27, you have to send the summons within 30 days. Is that fine? Summons
sir.
is supposed to be sent. Summons is supposed to be sent within 30 days. That is a mandate given to the court. Otherwise, the section would just sleep on it. So that is being avoided after the amendment. So 30 days is given. Now let me tell you one more thing. If there is some kind of section provides something, order generally will not be inconsistent with the section. But order gives an extra description. Then order is considered to be a part of the section. That is what section 122 of the CPC says. The effect of orders and rules vis-a-vis the section is they are equivalent, as if this is written into the section. So wherever a time is prescribed, then that time will have to be taken. And I don't think there should be any, the draftsmen have not made any inconsistency. I did not find anything. Can she just tell me what exactly or where she has found it? It says not beyond 30 days in section 27, right?
Yes, sir.
Yeah, it is not beyond 30 days. Correct. What I said is right.
Yes, sir. Okay, sir. So I hope Nishma's doubt has been clear. So the next question raised by Sachin Maurya is that whether amendments application under Order 6, Rule 17 can be entertained when the case has disposed of.
See, it cannot even be, amendment cannot be permitted in the normal course even when the trial is already commenced.
Yes, sir.
So disposal is much later. So generally it cannot be, otherwise there is no certainty, your trial is not based on, you don't get a certainty. In short, it is generally not permitted.
Yes, sir.
Order 6, Rule 17. Okay, there are other amendments which are permitted at a later stage, which comes under 32 and other things, Order 32. So I don't know if she is actually contemplating. Yeah.
Generally, it is not permitted.
Generally, it is not permitted. Yeah.
Okay. Thank you, sir.
After,
I hope
once the trial starts, it is not permitted because parties have to go on the pleadings. You cannot take them for stuff, like in surprise.
Okay, sir. Thank you, sir. I hope Sachin's doubt has been clear. Thank you so much, sir. Is there any queries or anything related to the topic?
There are a few others which I have received. Hello?
Yes, sir. Yes, you can speak.
There are a few others which I have received. What needs to be done to get a civil remedy in a time-bound manner? I think my class itself was based on that. Apply 11, 12, section. Now, there's just one more thing which I may say. Okay, is that right? Abhay.
Yes, sir.
Abhay
you can continue.
Yeah. He has asked me what is. One thing that I could not state is, and I think my young friend has already discussed on the summons. I don't know if she has discussed on the distinctive three types of summons. I'm not sure if she said on that. Summons for settlement of issues, summons for appearance, summons for disposal of suit. All these three are three different stages in the trial. Okay, some cases can be disposed of on the first day itself. So you have to let the judge know that he is supposed to issue that summons which is meant for disposal of the suit on the first day.
Okay.
As if she has not covered this, please look at Order 5. You will find these kind of 1, 2, 3, 4, 5. You will find these kind of three distinctive types of summonses depending on the case. Now, for something which you can dispose of on the basis of a summons for disposal, if you don't take that summons and if you give them the time to file written statement, etc., you are being negligent as a lawyer. Fine. So that is also an additional step apart from 11, 12, etc. Okay. Order 11, Order 12. Yeah.
Okay, Order 11, Order 12. Okay, taken that into consideration. Sir, moving on to the last question of our session, which is a very important, I think, for the new generation. That is, what are the new scopes for completing the procedures of civil suit within a small time span in the new era? Like, how can we complete the procedures of a civil suit?
Okay. No, see, the whole scheme of the class was, how do you avoid the delaying issues? Correct. The delay occurs because of two things. One is lawyers don't do things at the right time. You keep asking for adjournments. Second one is court is compelled to grant an adjournment under Order 17 because it has so much, it's overloaded with work. There are so many things which you can do by utilizing 11, 12. Finish of all that within the first 45 days itself. Immediately on filing suit, or immediately on receipt of notice of plaint, or immediately after filing of written statement. Now the maximum is 30 days for filing written statement. Once you get that, all the parties can exploit order 11, order 12, get all those documents placed. Don't wait for regular postings. So once you tell the court, I'll tell you one more excellent technique, that once you file these order 11 petitions, each time the judge listens to this particular application for passing an order, he is being appraised of the nature of the case. So after about 45 days, the court says, and I know everything about this case because we have moved at least 4 petitions, and each time I've looked into the facts. Now this is something which I can finish in a day's time because now I have learned the whole case. In other cases, he would not even look at it until he reaches the evidence stage or issue stage. So once he is revised, he will say, I'll finish this case off. It is simple. Do you get the point? So that is one way of, filing IA interlocutory applications and getting the judge know what my case is. Give him a revision every day.
Okay, that's so nice, sir. That's very informative one. So the last question in the chat box is whether is it possible for us to execute a res judicata and writs? Like in writ petitions, it is whether it is possible to execute a res judicata. The question was raised by Anandu Aravind.
Excellent. I'll tell you. See, for everything you add the word constructive, then it goes out of the CPC and applies it to proceedings which are not under CPC. You understand?
Yes, sir.
CPC is a very comprehensive code which has wonderful principles that a judge shall not decide the same thing twice. It is a criminal waste. Fine.
Yes, sir.
Now, even when it comes to writ, if the same question was agitated earlier, the court is not interested in looking at it. That is why when you file a writ today, they will even ask for an affidavit saying that the same issue cause was not agitated earlier. And you have to file the writ petition, affidavit along with the writ petition. This is basically to expose or disclose that these questions were never agitated before the court. Had this been agitated, and if you have concealed it, the High Court is going to grant you excellent cause.
Okay. Yes, sir. I get it.
So it is called constructive. I'll give you the test. Any principle which is there in CPC, if you want to apply it to something, you can
Yes, sir.
constructive as profile. That is the best way. Yeah.
I hope it's clear for Anandu that it's constructive. Thank you for all the answers for the queries raised by our participants. Now, I would like to move on to. Now, for that, I would like to invite Joy to propose the vote of thanks.
In the words of Oliver Goldsmith, and still they gazed, and still the wonder grew, that one small head could carry all he knew. Very warm good afternoon to all of you. Respected Director, Reverend Father Sebastian Vadakumpadan, Assistant Director, Reverend Father Biju Tekanath, beloved Principal Dr. V.S. Sebastian, Vice Principal Dr. Celine Abraham, our esteemed Speaker, Advocate Srilal Warrior Sir, our Mentor, Mr. M.E. Alia, teachers, and my wonderful participants. On behalf of Bharat Mata School of Legal Studies and Team Lex Conscientia, I consider my privilege to thank each and every one of you for your support and cooperation. Our Director, Reverend Father Sebastian Vadakumpadan, has been on guiding lines and support throughout the course of this journey. Thank you, Father. Let me express sincere thanks to our Assistant Director, Reverend Father Biju Tekanath. Thank you, Father. Special thanks to our Principal, Dr. V.S. Sebastian, who has been a strong and calming presence in our lives. Thank you, sir. I would like to thank our Vice Principal, Dr. Celine Abraham, for supporting us always. Thank you, Madam. Words are not enough to express our gratitude to to our guest speaker, Advocate Srilal Varya sir. His powerful presentation has left an indelible mark on minds of many future lawyers. We express our immense gratitude on behalf of Bharat Mata School of Legal Studies. We would also like to mention his support throughout the preparatory stages of our webinar. Thank you, sir. Our mentor, Mr. M.A. Aliar, has been our go-to person, and the trust he bestowed on the team is immeasurable. Thank you, sir. I would like to thank all our teachers for the guidance and support in this journey. Thanks to our student presentators, Ms. Sinu Sebastian and Ms. Alsana for their informative presentations. Even like this cannot happen overnight. The wheels start rolling week ago. It requires planning and a bird eye for detail. I would like to take this opportunity to place on record our hearty thanks to Dr. Anna ma'am, our pillar of strength. Thank you, ma'am. Last but not the least, I would like to thank my classmates, the wonderful BA LLB 2016-21 batch, for all the hard work and passion they have invested in this program. Special thanks to my fellow student coordinator, Mr. Ajin Salam, for his unending efforts. Thank you one and all. We look forward to seeing you soon in future. Good luck to everyone. Thank you.
Thank you, Adira. That was so nice of you. Now, we would like to inform you that a feedback link have been sent in the chat box, and the participants may be requested to fill them so as to attain your e-certificate. I repeat, we would like to inform you that we have placed a feedback link on the chat box, and the participants may fill the link given so as to attain your e-certificate. Thank you.
I would like to conclude our international webinar, Lex Conscientia 2020, by quoting that injustice everywhere is a threat to justice everywhere. These are not my words, but they are the words of a great leader, Martin Luther King. I hope today's session have enlightened you all to fight the injustice everywhere so that justice sustain everywhere. Thank you all for your participation. Thank you and have a nice day. This is your moderator, Alphonse Rustomas and Abhijit Mohanlal signing off.